Hi everyone, and welcome to Vienna Arbitration Talks. Today I'm hosting a very special guest on the line directly from the Kyiv region in Ukraine, Olena Perepelynska. Olena is the head of international arbitration at Integrites, one of the most renowned Ukrainian law firms, and she is the president of the Ukrainian Arbitration Association. Besides that, she is a member of a number of other professional bodies and organizations, such as the ICC Commission and the ICC Court. She's a very experienced arbitration practitioner and has been involved as counsel, arbitrator, and expert in about 170 arbitrations in Kyiv, Vienna, London, Paris, Stockholm, Bishkek, and Almaty. Olena, that seems like a lot of work, right? How are you? Welcome to Vienna Arbitration Talks.
Thank you. Greetings to everyone, and thank you for inviting me here. I am very pleased to see everyone online, even in these difficult times.
Thank you so much for taking the time to join us. First, I'm really happy to hear and see that you and your family are safe. Luckily, things have been settling down in the Kyiv region, and you could also return back to your home, right? But it must have been quite a horrible and scary experience, no?
Yeah, we were not prepared, definitely, for such an experience in our lives. So on 24th of February, I woke up because of the explosion sounds nearby my house, and that was really scary. And after several days of staying in the Kyiv region, it was too risky and too scary. So we decided to flee with my family to a safer part of Ukraine in Chernivtsi region, which is closer to Romanian border. And in May we have returned back home, and I'm really happy to be at home again, because, you know, I have never thought about the importance of home, in our lives, and this really gives strength. This distracts from some sad thoughts, because you could do your hobby. I could do my, for instance, gardening.
You sent me a couple of photos before, right? Yeah, we will show those. Those are beautiful. Yeah. Those are beautiful. So you could come back to your flowers, hopefully.
Yes.
You said that your town was then also targeted by air raids, right?
Yeah, it was a hot place. My town is called Kyiv, and it was one of the targets of Russian army in the first stage of war, because of its strategic location and because there is a small military airdrome somewhere nearby, and that is why they wanted to seize it and use it as a platform for attack of Kyiv. And now it's more or less safe. Okay, relatively safe as everywhere in Ukraine, because of course we have sirenes regularly, and there is a risk of missiles attacks, so this does not disappear, but we have learned to live with that.
But you came back to your house, which is hopefully intact, and your roses are also on the way to start blooming, right?
Yeah, they have just started, and I hope to see some nice flowers soon.
So to have a bit of a hobby like this, I see you're also wearing a Vyshivanka, right? That there was recently there was the Vyshivanka day, right?
Yeah. Usually we have it in the end of May, just a couple of weeks ago, and this is my recent addition to my collection. So this is really nice, and I like. I like the idea of such nice national clothes, and I'm happy that now it's so trendy, because I really like it personally.
Yeah, it was a couple of weeks ago, I think, right? That there was the holiday, or the day. Basically, there was a gathering out right over here in front of the Stephansdom. And,
I was also there.
I was probably one of the rare people that didn't wear it. So yeah. Olena, I wanted to talk to you today about some legal remedies for these economic losses that have basically occurred during the war, because besides all the horrible atrocities of this war, a lot of property has been destroyed or damaged. And according to the most recent data of the Kyiv School of Economics, The direct economic losses incurred in Ukraine since the beginning of the war have exceeded $600 billion, which is crazy. Which is a lot of money. As a lawyer, and especially as a commercial lawyer, I'm sure you've received many questions from your clients on how to recover such losses now, or basically what to do now. What kind of losses do your clients face?
So, of course, there are different categories of clients with different problems. Briefly, I could describe them. So some clients have assets on the territory controlled by Ukraine, and these assets might be either destroyed or damaged. Other clients have assets located on the recently occupied territories. And again, there could be different scenarios what happened with those assets, because some could be again destroyed or damaged, some could be simply stolen, some could be out of control and no connection with people and with the assets now exist. And in addition, we have one new category because Ukraine has liberated certain, deoccupied some territories like Bucha, Irpin, for instance, and there are also clients with assets there, so which have been occupied and then deoccupied, and again there are different types of problems arising out of that occupation. And of course, all of them are asking what to do, how to receive a kind of compensation from Russia. And this is, of course, one of the hot topics now because the available tools, legal tools, are very limited. If to mention them briefly, this is Ukrainian court litigation. This is a possibility for certain types of claims and clients to go to the European Court on Human Rights, and even to a more narrow category to probably launch investment arbitration. And there are certain options discussed additionally, like claims commissions, like foreign court litigation, but so far they could not be considered, as I understand, as an existing tool, because they have not been launched properly yet, and there is a need of certain amendments on new regulation to enable such avenues.
And these are basically all of these avenues we wanted to discuss during our talk today. First, as I understand already now, registration of these damages, of the losses, is already in progress. As I learned my last time when I was in Kyiv, Ukraine is quite a high-tech country, and I heard that people can now report these damages caused by the occupying troops straight in this Citizens app, right?
So we have different channels of sharing information with the state, and from first days of the war, the state launched different initiatives in order to collect information about the losses suffered by Ukrainian citizens and businesses. One of such channels was a special website created by Kyiv School of Economics together with the government damaged in UAE. This website collects information about damages suffered by the Ukrainian business. We also have an app which was initially launched for different purposes called DIA, which is translated as action. And this application is used as an electronic form of documents, of COVID certificates, and recently they have added some additional functions like reporting damages, but this mostly applies in the app. This applies to the individuals. However, you need to understand that registration of damages does not mean that this automatically entails full compensation of those damages.
Of course,
this information is simply collected by the state for different purposes, for war crimes to be properly prosecuted, to explain to international, to foreign countries what is happening in Ukraine, to again to launch some initiatives to confiscate Russian assets, etc., etc. So,
so Olena, once things have been registered, you mentioned the lawyers will come in. What are the plans in Ukraine as regards legal proceedings deciding on such damages claims? And I want to ask you, can under Ukrainian law the Russian Federation or its citizens be accountable for their acts in front of Ukrainian courts?
A brief answer is yes. With citizens, it is easier because they do not have any sovereign immunity, and Ukrainian prosecutor office is investigating now different war crimes against Russian citizens. With regard to the state, it's more complicated because the Ukrainian existing legislation respects the absolute immunity, and we have respective provision in our law on private international law. However, recently the Supreme Court rendered an interesting decision regarding Russian sovereign immunity. It was an old case related to Donbass occupation, and in that case the Supreme Court decided that in this particular situation, because of the international law, Russia should not have sovereign immunity against the claims delicts it committed on the Ukrainian territory. And in addition to the first decision rendered several weeks ago, just this week, the Supreme Court shared information about yet another decision where it developed its argumentation and confirmed that for the purposes of prosecuting Russia or considering claims against the Russian Federation for the acts committed during this war, Russia will not have sovereign immunity because Ukrainian courts consider this should be so by virtue of international law.
Then we have maybe the issue of enforcement, of course.
Actually, so this means, but this recent practice of the Supreme Court means that now Ukrainian courts could entertain the claims of Ukrainian business against Russian Federation. However, of course, it does not solve the problem of enforcement of these judgments to be rendered by the Ukrainian courts. And I have doubts whether those judgments could be easily enforced in Ukraine because Ukraine is confiscating all available Russian assets and is going to use them for more structured compensation, so to say. And that is why private creditors should compete with the state, which I think is difficult. And that is why those judgments should probably be enforced in other jurisdictions. And again, this is complicated, and we will have another round of sovereign immunity problems in any other jurisdictions, unless the legislation would be amended to enable such enforcement.
You mentioned claims commissions, and are there any plans to establish such, internationally backed bodies to decide on these kind of claims?
Yes, the Ukrainian government sends different signals. First, it has created several funds. One of them could be called the Fund for Rebuilding Damaged Infrastructure and Compensation of Damages. That is purely national fund. And no proceedings has been established to consider claims to be funded by that fund. Additionally, quite recently, different high officials, including Deputy Minister of Ukraine, Minister of Justice of Ukraine, explained the plans of Ukrainian government to launch an international claims commission together with the support of other countries. So it should be something international. And the problems of this claims commission is, if we compare it with others claim commission existing before, is that those claims commission always operated with the consent of the respondent state. And the problem of all Ukrainian claimants and victims of this war is that Russia does not consent to anything. It does not consent to any compensation. And frankly speaking, we do not believe that even if we once sign a peace treaty, there would be a clause about reparations. The issue of reparation has never been, I think, on the table during the negotiations with Russia. And if we don't have such a peace treaty with reparation clause, then we need to find a way to somehow recover those damages in absence of Russian consent. We have seen already that Russia will simply ignore any court, even international court judgments or decisions. And I don't think we will be able to enforce anything in the territory of the Russian Federation. So we need to find a way to enforce it outside Russia, and for these purposes we probably need to create a kind of international fund, and this claims commission could operate using those funds, but in order to make it more legitimate, we need the wide support of other countries, so it should be really an international body recognized by the civilized world.
And this kind of an international body would use for repayment of such claims assets that have been frozen in the Western countries, I would imagine, or how would that work?
The idea to fill in this fund with different types of assets, and first of all, yes, the assets, Russian assets confiscated elsewhere. And this could include either sovereign or non-sovereign assets. And of course, this is a separate amount of work yet to be done. Ukraine has already started confiscating assets of various Russian citizens, companies, and the state on its territory. And we hope that other countries will amend their legislation to enable similar confiscation on their territories. And this could include either sovereign assets or assets of Russian oligarchs. And we know that this is a difficult topic. We know that there are a lot of problems. We know that this has never been done in such a scale. And but still, some countries are developing such draft laws to enable it. And I would just mention Canada and the US, where there are several draft laws using several different concepts how to legitimize such a confiscation, because there are so many assets frozen already around the world, but they still belong to their Russian owners. And the problem is how to convert them from Russian assets into the assets or proceeds to be used for rebuilding Ukraine, for compensation of damages. And different concepts are used to legitimize that, for instance, corruption, terrorism, either illegal means of obtaining those assets. So you could, of course, imagine different scenarios why such confiscation could be legitimate, but you definitely need to amend the existing legislation in order to extend those confiscation to the assets frozen, for instance, under different sanctions laws. And I hope that once first such laws would be adopted, other countries would follow the examples.
Olena, my final questions for today, and this touches the horrible destruction and atrocities we witnessed in Mariupol and in the region. If we focus on the economic aspects, and you have mentioned investment arbitration before, the other day I read about Mr. Akhmetov's announcement that he intends to bring a claim against Russia worth $20 billion over the destruction of assets in the area. He hasn't mentioned investment arbitration, but I guess that would probably be the avenue to pursue such claims. There have been several cases before regarding the assets of Ukrainian companies in Crimea. What could be the challenges or basically the strategy for investors in pursuing such claims under the Ukraine-Russia BIT?
So it's a very interesting question. First, I don't know whether Mr. Akhmetov is going to choose investment treaty arbitration because, as I mentioned, there are different avenues already in place and some to be launched soon. But in any case, investment treaty arbitration is one of the options which is now discussed by some Ukrainian businesses, particularly if the assets of that business are located on the occupied territories. And the reason is that 8 years ago, when Russia annexed Crimea, nobody believed that investment treaty arbitration under Russian-Ukrainian BAT with regard to the assets located in Crimea would be successful. Because, again, the BIT was not designed for annexation or occupation of territories, and there were clear problems and challenges. However, so far, these Crimea cases prove that it is possible to apply BATs to the situation of occupation of territories and make Russia liable for all done in the occupied territories. And that is why, of course, now we see parallel in recent occupation. Of course, this recent occupation is absolutely different. And this is a military occupation of different levels. However, Russia has already introduced on some territories its currency, its language, its temporary administration. There are a lot of talks of just go into some referendums. You know that even in some controlled territories, when children are born, they receive the certificate of birth issued by the Russian Federation. Although it is a Ukrainian territory. There are a lot of nuances. They are different for different territories because the situation is, again, not the same, and some regions are still bombed and there are atrocities and hostilities. Some are more quiet, but again, there are a lot of problems. And that is why the natural idea is to use the avenues already done by tribunals in Crimea cases, probably to interpret the Ukraine-Russia BAT even more broadly in order to encompass the situation of recent occupation Ukraine has now. Of course, BAT is not designed for wars. It is not designed for occupation of territories. But when you don't have other legal means to get compensation, you would consider every possible solution. And probably the tribunals in these new cases would be also creative and brave enough to confirm the jurisdiction of in those cases. So
well, it's
we'll
all
see.
a matter of interpretation, right? Like in arbitration, often or always is. Olena, thank you so much for taking the time to talk to me today. I think you're probably already really busy helping your clients rebuilding your country, right?
Yes, thank you for inviting me. It was really nice to talk to you, and hopefully we will build everything, rebuild everything, and we'll help Russia liable for that.
Yeah,
this is really important now.
Of course. Well, we all hope that the war ends soon, so that you can start and do all of these things again. But you know, I hope to see you in Kyiv soon for one of the arbitration events. But until then, all best wishes to you and your family and your nation, of course. Slava Ukraini.
Thank you. Героям слава. Thank you very much.
Thank you, Olena. Dear viewers, before we finish today, you may remember that we hosted the creators of the humanitarian relief projects unitedforukraine.org and ukrainlegalaid.org in our previous episode. If you can help in any way, which is to provide accommodation, to provide legal advice, please go to their websites and register. You will find the links again in the comment below. Thanks for watching us again, and greetings from Vienna.